Good evening, viewers. Welcome to another episode of COVIDCASTJA. I am your host, Rochelle Cameron. Today, October 29th, we are at episode 30, and today we're talking about managing redundancy. Episode 30 technically is our 30th anniversary, and traditionally that was your pearl anniversary, and today it's diamonds. I'm going for the traditional celebration of it. Today we have with us eminent counsel, an attorney at law, Gavin Goffe. He'll be with us shortly. Just reminding you that every week, so we are at episode 30, which means that we have so far issued 30 SME memos. So for every week that we have the show, we issue a memo that gets into the details in very easy, digestible language, gets into the details of the subject that we are talking about. If you have not been receiving your SME memo, please email us right now at sme@psoj.org and get your weekly copy. It's great business tips. If you're also just joining us for the first time, we are here every Thursday at 7:30 p.m. That means that you have missed 29 episodes, so you can spend this weekend binge watching COVIDCASTJA. Welcome Tamika Bailey, welcome Max North, hi Romeo, glad to have you all. Now let me just jump right in because we're going to have some stimulating discussion and conversation today with Gavin Goffe, who is an attorney at law at Myers, Fletcher and Gordon. Now, Gavin is an attorney that I have a lot of respect for, very knowledgeable. But the great thing with Gavin is that he's so good at breaking down very complex issues in a way that anybody can understand. So glad you joined us today. Now, Gavin has spent much of his career advocating for employment law reform for the mutual benefit of businesses and workers. Gavin's line of practice is generally focused on industrial relations pertaining to the law and its practice. In being the rounded lawyer that he is, Gavin holds membership positions in areas such as being an honorary counsel to the British High Commission in Jamaica, a member in the Council of the Jamaica Bar Association, where he also sits on the Employment Law Committee. And he's both a member and the former chairman of the advisory board of the Salvation Army Eastern Jamaica Division. With an interest in improving the lives of those around him and thus making a positive impact on Jamaican society, Gavin, alongside his wife, co-founded Adult Learning Centers of Jamaica, which is a non-profit organization geared towards the improvement of adult literacy and numeracy. And today, Gavin is going to be talking to us about managing redundancy. Hello, Gavin. Love that shirt.
Hi, Rochelle. Thank you very much. It's Breast Cancer Awareness Month still, so I said right before the month is out, I'm going to wear my pink.
Yes, and real men wear pink. Thank you very much, Gavin. So, Gavin, we're going to be talking today about managing redundancy. I know, especially during this COVID period, you have actually published a few articles and you have been giving quite a few presentations on this area of employment law. Employment law is one of those things that everybody thinks they know, and everybody knows that they don't know. And it is, when we're discussing it, it always is around the facts of the case and situation analysis. So one of the things today is that we're going to be setting just some base understanding of some of the terms, because you know how we'll use terms loosely in Jamaica. So I actually want to start just from the base. Now, everybody, when we work with people, we say, I work with Mr. Goffe. Mr. Goffe, I'm a boss, which means I'm an employee. Now, what is the difference, Gavin, between an employee and an independent contractor?
Okay, cool. So an independent contractor is basically somebody who works for himself or herself, right? So they take all the risk, they make all the decisions as to whether to work, when to work, and how to do the work. And they charge a fee usually for getting the job done. Sometimes that fee can be broken down in terms of time spent on a matter, but they're not being paid necessarily as an employee to work for somebody else. So what the law says is that you are entering into a contract to provide a service as opposed to a contract of service where you are the person who is in a master servant type relationship with an employer. So an employee, on the other hand, doesn't have that kind of control and flexibility. They are told what to do generally. They are very often given the tools that they need to do their employer's job, and then they collect remuneration based on the agreement with the employer.
Okay. So employees, for example, would be able to get things like vacation leave.
Yes, employees will get vacation leave, employees get sick leave. If you are self-employed, then nobody's paying you if you're not actually working.
Okay.
Nobody's giving you maternity leave if you are self-employed.
Ah,
Nobody is giving you any redundancy payment if you are self-employed.
okay. So Gavin, as we even talk about the different types of employment and different type of workers too,
Yeah.
there's seasonal workers, casual laborers. What's a seasonal worker and what's the definition of a casual laborer?
All right, these are pretty complex terms. Unfortunately, our law doesn't really do as much as it should in terms of defining these terms. But for seasonal employment, as the name suggests, it's usually somebody who is not employed throughout the year, but is employed for the same period of time each year. All right. So, for instance, if you're in agriculture and you're in a particular, there's a particular crop which has a season when it needs to be picked, then you will be brought in only when that crop is ready to be picked. Tourism, if you are brought in during the tourist winter season, then you know that you'll probably be working from the start of December until about maybe March, April. Now, in terms of casual worker, what the law says is that a casual worker is somebody who is hired for a job which usually takes more than one day. So it's almost like an ad hoc relationship. So as and when the person is needed, they are called and they are paid for the day's wages, but they don't actually have a schedule to say you are to come on for 8 hours, 3 or 4 days a week for the next few months. So basically, a casual worker is somebody who's given a task as opposed to being told come to work on these particular days. And so if there's no work to give a casual worker, they don't work, they don't get paid. But if you're an employee and there's no work to give the employee, you still expect to get your check because you came and you showed up. If you don't have any work to give me, that's your problem.
Okay. No, and I like how you segued in, you don't have any work to give me. So COVID has highlighted a lot of these terms.
Yes.
So I know there are several people who didn't understand or have never really even heard of being laid off. And, we've heard of various redundancy exercises, but redundancy and being laid off, as it is set out in the law, have now been highlighted as a result of COVID. Businesses have had to close, they've had to reduce their hours, they've had to reduce the production based on curfew, based on just reduction in demand. And we've seen a lot of that in the tourist industry. So I want you to start by just tell us what is redundancy, versus being laid off. And then we're going to get into a discussion of to whom does redundancy apply? Because we've
Okay.
talked about different type of workers and we know that it doesn't apply to everybody. So, you know, so today somebody said to me, Miss Cameron, I got to talk about redundancy today. Miss I got to talk about redundancy. So tell me about redundancy. What is that?
All right. Well, I'm going to start with layoff first and then move
Okay.
into redundancy. Okay. So a layoff is actually a temporary suspension in the employment relationship, but still maintaining that you are an employee. So it's a suspension in the sense that the employee doesn't go to work
Mm-hmm.
and they don't get paid. But all their tenure with the company or with the employer continues on paper. So they're
Okay.
still on the books, but not in their payroll.
Mm-hmm.
And so they're still employed and would still be governed by the employment contract, except where it comes to going to work and getting paid. All right. So that's a layoff. And our
Okay.
law says, our law has a provision in there which essentially allows businesses some breathing room in the event of a pandemic like this or some other unforeseen circumstance, which the business needs to essentially have a timeout so that
Mm-hmm.
they can recover. So the law builds in this layoff to give employers that ability to call time and send you home without any pay, and if that to give them a chance to regroup and hopefully come back and bring you back on. Now the law says that you can't claim redundancy until after 120 days has passed. Now let me indicate what redundancy is so we can tie it back to the layoff. Now redundancy is the termination of your employment in the circumstances where the business can no longer provide you with the work, or they're going out of business, or essentially they don't need you any longer because they've found a way to carry out the functions you are doing without you being there.
Okay.
Okay, and without bringing in somebody else in.
Mm-hmm.
So it may be a case, give you an example, you might have a supermarket that has 8 cashiers. COVID has hit. They really aren't doing as much business as before. So instead of 8 cashiers, they say, you know what, we can only afford to pay for 6 cashiers. So 2
Yeah.
people are going to have to be made redundant. And there's a whole process about that. So redundancy, like I said, is a situation where you don't have any business or any work to give these employees, and so you are terminating the relationship permanently,
Mm-hmm.
or at least for the foreseeable future, you're terminating the relationship. So taking it back to now the layoff. So a layoff situation actually is the same kind of situation that would trigger redundancy. Because in a layoff, just like in the pandemic, your business might essentially be closed, and so you're not earning enough money to be able to maintain the full staff complement. So the law says that we're going to give employers the ability to call time, and up to 120 days, the employee can't claim that they have been made redundant. So it's a kind of a restraining period, telling the employees to hold on, give them 4 months. Let's see if we can get back on track.
Okay.
Before that 4 months happen, before the 4 months has expired, hopefully the business is able to bring you back. And when they do bring you back, you're not entitled to be paid for the time that you've been out, unfortunately. Because of course, there's really no money to pay you. In many cases, the business wasn't even earning any money in that intervening period. So you come back and you don't get the back pay, you start over essentially once they call you back, and you get paid going forward. If they
Okay. So
don't,
that, stop there a second. So a business has
yeah.
made a particular employee, has laid them off. When the employee is home for the layoff period, so that's the first question. When they're home for the layoff period, they're not getting any pay.
Mhm.
Can that employee go and work somewhere else during that time?
Remember I said that they're still bound by their employment contract. So it really depends on what the contract says. Now,
Okay.
very often, depending on the seniority of the person, the more senior you are, the more likely you're going to have some non-compete or confidentiality clauses in your contract, which might make it either difficult or impossible or a breach of your contract if you were to go and work for somebody else. Now, during this time, a lot of employers, especially my clients, have been saying that you can, if you're fortunate enough to be able to find a job, go ahead and work for that person as long as it's not, let's say, a competitor of mine. Okay?
Okay.
So as long as it's not a competitor, go ahead and work for it. Or sometimes they'll say, even if it's a competitor, as long as you're not taking over any of my confidential information over there, go ahead, go for it, and do your thing. But if there's no provision in your contract which prevents you from working for a competitor, then I guess the short answer is that you probably can. Your boss is probably not going to be very happy about it, but there's actually no legal barrier preventing it.
Okay. So when your employer say calls you back and they call you back on day 100, you haven't been paid for 100 days. And when you are called back, what about things like your vacation leave? Do your vacation leave entitlements still compound during the time, or is it that during that 100-day period, any vacation that would have that you would have accumulated at the time, those days are gone?
No. Any vacation leave you would have accumulated up to the point that you were laid off, you still maintain all of that vacation leave. You still maintain all of that. So it doesn't
Okay.
get back. And in fact,
So, Gavin,
what some people have done, what some people have done is that when their boss comes to them and says, I'm going to have to lay you off, they actually will sometimes say, instead, could I use up, or the 50 or 60 or 80 vacation days which I have already accumulated? Because if you're using up, because if I make you redundant anyway, I'm going to have to pay you for all of those days, right? Because you get paid for your unused vacation no matter the reason that you are no longer there, whether you're fired, whether you're made redundant, whether you resign, you're entitled to be paid for your unused vacation. So from the business perspective, that might be a good compromise in saying, okay, I really don't have the cash flow right now to pay you, but it's better that I pay you for your vacation now, because that's a liability which I was carrying on my books in any event. And it means that the employee can continue to earn money during that what would otherwise be a layoff period. The only thing is you can't be on layoff and on vacation at the same time. So you got to pick one.
So, Gavin, a while ago you just mentioned being fired. Just for clarity, is there, we use fired for so many things. When you are made redundant, are you fired?
Technically, yes. A redundancy requires there to be a dismissal. Okay. So you have to be dismissed in order for you to be dismissed by reason of redundancy, which is then when you get the redundancy payment. But typically, when people say you're fired, they really mean that you're being fired for cause, which is not the same thing as being made redundant. If somebody is firing you for cause, you would not be entitled to a redundancy payment.
Okay. So in terms of a redundancy payment, since we're touching on that point, how are redundancy payments, as I know various organizations will calculate and have different add-ons to it, but what does the law provide for redundancy payments, for the calculation?
Sure. So redundancy payment, firstly, you have to be employed for 2 years uninterrupted. Okay. And not, it's not kind of 2 years, it's not 2 years-ish, rounding up to 2 years. If you're not there for 104 weeks complete, then you're not entitled to redundancy payment. That's the first thing. And the formula is that you're entitled to 2 weeks normal wages up to the first 10 years of employment. And from year 10 onwards, it's 3 weeks per year.
Okay.
So again, 2 weeks per year up to year 10. From year 10 onwards, 3 weeks per year. And again, I said normal wages, so you wouldn't include things like overtime, you wouldn't include your lunch allowance, your car allowance, or any of those types of things, but you would include, for instance, any commission payments that you might be entitled to, and there's a way that you would average out the commissions over the last 3 months to get what your average weekly commissions would be. And any bonuses regularly received. I'm not talking no like a Christmas bonus, but if, for instance, as part of your job, if you do this or if you do that, you can get a bonus. If you introduce these number of clients or customers, you can get a bonus. Those kinds of things are included as normal wages. And again, you treat it like the commission and you average it out over the last 3 months. Yeah.
So do seasonal workers and casual laborers or casual workers, are they entitled to redundancy? Because
yeah, the casual workers, the seasonal workers are entitled to redundancy. The way you work it out is slightly different and it's kind of complicated, so we're not really going to get into that aspect of it. But the casual workers generally are not. Because casual workers, I mean, it's true, I have seen a few cases where some people have been treated as a casual worker for many, many years.
yes,
Uninterrupted, every single day, work day, casual for 3 years. I've seen it. And if you're watching this, you know who you are and you just stop that nonsense. But most times, casual workers would never really reach up to even a 1 year mark, much less 2 years.
okay.
Yeah.
So Gavin, for the 120 days, I know at the beginning of COVID in March and April, people were starting to calculate how long that 100 and where that 120 days would have taken us.
Yeah.
By any stretch of the imagination, we've passed most of those 120 days that would have started in March or April. So say someone was laid off in April of this year,
Right.
120 days. So laid off and not called back. Now, and actually, let me ask this first, because I know a couple of people have been saying that my employer called me back at day 25 and then sent me back home at day 36. Can this happen? Well, it happened.
Should it happen?
Yeah.
You know, that's something which I've been in dialogue with the Ministry of Labour about now for many months. Unfortunately, I haven't gotten anywhere. There was a regulation which should have been put in place to control that type of activity. It should have been put in place from before I was born. And I mean, I know I look very young, but it's 40 years now. They have been dilly-dallying and not putting this regulation in place. If that regulation were in place, that wouldn't be allowed. However, because it is not in place, there is nothing in our law that prevents somebody from calling you back on day 25 and you're working as normal for a week, 2 weeks, and then saying, I'm sorry, I thought this was going to work out, but it's not, and I'm laying you off again, and I've now reset the clock, and you're now on day 1 of your layoff all over again.
Okay. All right. So 120 days have passed. The employee has not been called back. You mentioned that the employee cannot claim redundancy before the 120 days have passed. Can you clarify what the claiming of redundancy is and what happens where claiming of redundancy is concerned at day 121?
Okay, so what you're required to do is send a notice to your employer indicating that you're electing to be dismissed by reason of redundancy.
Gavin, that sound hard. Suppose like me did, like me no know what electing is. Me only know
Yeah.
electing in terms of
You know election, you know election. All right. For the people who don't know anything about election, on our website, milesfletcher.com, we've given a sample of the form. So you just need to go there, look in our resource section, you can download the form, and it even has some instructions at the bottom as to how to fill it out. All right.
Oh,
So you fill out that form, and one thing that a lot of people don't realize and a lot of mistakes are being made is that people are filling out the form and sending it in and not selecting the right date for when it's to take effect. But the law says you can't send in the form today and elect to be dismissed by reason of redundancy at the same time. All right?
oh,
So you must give the employer at least 14 days notice and no more than 60 days notice. All right? So if today, 29th of October, they download the form and they fill it out and they send it off, it's going to be at least the 13th of November is the date that they should enter in there as to when they're electing to be dismissed by reason of redundancy. Now, that period of time of at least 14 days is to give the business an opportunity to see if they can bring you back.
okay.
Yeah, so you give the notice, you say, boss, you have 14 days to either bring me back or make me redundant and pay me. And then the business can then gauge and work out its figures and see, okay, let me see if I can bring you back. And if they bring you back on the same terms and conditions before that 14-day period or whatever day period you have selected, then you no longer be entitled to redundancy because you're now back on the job.
Okay.
All right. So it's kind of triggering. It's triggering really an election on the part of the employer to say, bring me back or let me go and pay me. Yeah.
Okay. The Negrito, I see your question. I just want to acknowledge Negrito's question, which is if sales commission are a part of an individual's remuneration, should it be included in the redundancy calculations? You had touched on that, Gavin.
Yeah. The answer is yes.
So the answer to that, Negrita, is yes.
And Negrita, on our website, we also have a calculator to help you work it out. So if you go on the website, you can enter exactly what your compensation is and the date that you will be made redundant and the date that you started, and we'll give you an estimate of what the redundancy payment is.
Okay. Oh, thanks for that, Miles Fletcher.
Yes.
Yes. So we have a poll. Have you been laid off or made redundant this year? And 6% of our respondents said yes, and 94% said no. Brenda Palmer, Brenda, you're asking how can we access this conversation after the live is ended? The conversation will be right on the Facebook site and it's also on YouTube. So it's going to be on Facebook right after, and you can just use the time to watch the rest of them too. Nobody go to your bed tonight. So in fact, we had some discussions with Carla and Roper Harris earlier this year. Yes, Roper to the world. We discussed some of these terms, and the question we were saying, okay, now when 120 days have passed and you have actually gone through with us this trigger, and it's a term that has been used that I don't think people understand, that the employee has to claim the redundancy. Now, just to be clear, if the employee is waiting to be made redundant by the employer, nothing happens until the employee actually sends that notice.
Right. No, the employer might come around and say, I'm going to make you redundant now, or they might say, I'm going to bring you back. But in terms of waiting and expecting a check to come, you really shouldn't do that. If you're really in need of that money now, it's best to start the process as soon as possible, especially if you're pretty sure that you're not going to get that call back. Send the notice and let the employer do what they need to do.
So, Gavin, is there an expiration date that the employee needs to send in that claim for redundancy?
No, there is no expiration date, and it's important I say this because there's some misinformation out there that says that you have 60 days after the 120 days to make the claim. That's not correct. That's actually misleading. Very unfortunate statement. You don't have any deadline in the law to make that election, and for some people, it would be better for them to wait. So let's say, for argument's sake, you've been employed for a year and a half and you've been made redundant for 4 months. Sorry, you've been laid off for 4 months, which then takes you up to a year and 10 months. There's no point in you sending in an election at that point in time because you wouldn't yet be entitled to a redundancy payment since you don't have 2 years of service. But if you wait on another 2 months until you reach that 2-year anniversary mark and then send in the notice, you get 4 weeks redundancy payment.
Thanks for that, Gavin.
You go.
Because there is quite a bit of misinformation about, I call it one of the COVID myths, that 60-day period.
Yeah.
Gavin,
I also want to say, I just want to add on to that point, if I may. I said before that it's 2 years for every year up to 10 years. But there's also fractional periods of the year. So if you've been working for 2 years and 4 months, we round that up to 2.5. And if you've been working for 2 years and 10 months, we round that up to 3. So again, it's always important to know when you're crossing the next milestone or the next threshold, because then that can help you to strategically send in a notice electing to be made redundant on your next milestone date.
Okay. So it would be important then that employees actually know when their employment date commenced.
Absolutely. Everybody should know that.
Yeah. Because, sometimes people, that initial letter and those things, sometimes people can't remember exactly when. And it is important that we are responsible with that. Now, one of the things too that a few employees, people have come and they're asking this question. They're saying, okay, I send in the form, I claim in the redundancy. 14 days have passed. On day 16, should I be checking my bank account for my redundancy payment?
You should, but I'm not sure it'd be very encouraged to do so. The fact is that because of COVID, we understand that people don't really have the kind of cash flow that they had before. And especially if your redundancy payment is several hundred thousands or maybe even millions of dollars, it's likely that your employer is going to need some time. And that could mean, for instance, as much as 6 months or even a year later, you're receiving your redundancy payment in small bits and pieces. Now, it's important that people dialogue and come to some kind of meaningful arrangement that's fair to both sides. But the fact is that, unfortunately, there's no timeline in our law by when an employer must complete the redundancy payment. Some people think that the law says you must pay them off in 6 months. Actually, it's completely silent on it.
So if you've seen 1 year pass,
sorry, you shouldn't wait to see 1 year pass, because there's also a limitation period in the law of 6 months. And if you haven't claimed your redundancy payment 6 months after it's become due to you, then you could end up waiving or losing the right entirely. So what you really want to do is, on that 16th day, let's say you elected and you gave 14 days notice, on that 16th day, you should be reaching out to your employer to say, okay, when will I receive this payment? Can we work out something where I even get paid a lump sum up front, and then maybe I can get my normal salary for the next 3-4 months until it's paid. Something along that line I would really encourage. Don't wait though.
Okay. Gavin, there's something I want you to clarify for me.
Yeah.
With these various means of communication now, WhatsApp, email, etc. When
Mhm.
they say you were to go on Mass Fletcher Gordon website and you fill out the form and you elect to be made redundant, is there an appropriate way to send that form in? Is it that you are to print the form and hand it in? Can you send it via email? Can you simply attach it to a WhatsApp message and say, hey, boss, please see the document here? Is there an appropriate way to send in that form?
There are no inappropriate ones, but there are best practices and there are worst practices. Okay. So the best practice, of course, would be to physically take it to your employer and have them sign to confirm that they have received it. That's the best practice. Second best would probably be putting it in the old school envelope with a stamp and sending it registered post, preferably to your employer. If you're not doing that, email can also work. I would encourage you, however, to make sure you sign it. And even if you want to scan it and then email it, and then confirm that they've
Mhm.
received it by a follow-up call. Now, here's the key. No matter what method you use, the most important thing is that you actually have proof that it's been received. So even if it's a WhatsApp message, if you send it via WhatsApp and your employer responds and says received, that's fine, because that's all you need to make sure that they have received the notice. The problem gets in where you send it via WhatsApp and then just lock down the phone and say done without confirming that it's actually been sent to the right people, they didn't bounce, or you haven't been blocked, something of that nature. So
Yeah.
best practice is having it hard copy with a signature on it, but anything where you can prove that it's been sent, that's what I'd recommend.
Okay. So flipping now to the employer. The employer, in as regards laying off, because some employers are in fact just going down that road, having gone to the second wave of COVID. Um,
Mhm.
how are employers, or how were employers expected to have notified an employee of layoff?
Ooh, that's a good question. There's nothing in the law that says how it should be done. But in fact, we do have some general principles of communication in employment and industrial relations. Um, and any HR person will say to you that the best way of communicating is actually in writing. But there's nothing wrong with having a verbal conversation, but I would always recommend that you follow it up in writing. What I don't recommend is essentially locking the door on people and essentially saying, it's a COVID a keep, and
Yeah.
essentially expecting people to understand that they are on layoff without you having to say it. That really isn't good behavior.
Okay. So, um, assuming that most employers acted in some kind of fair manner to inform their employees of layoff, during that 120-day period, are they supposed to be giving updates to say, this is what is happening now? No, we're not calling you back yet. Or is it that they are to wait to the end of 120 days and then they're like, this is what's happening now? What's the
You know,
guy?
it varies. A lot of employers are not communicating, and that's unfortunate. Um, some people feel that if you're on layoff, I really shouldn't be sending you any message because it's almost like I'm giving you work. And that's really not the way we should look at it.
So suppose you
Content,
ask for a file, Gavin. Suppose you
yeah,
said say, um, where the file is, or you actually need the person to come in for 2 days. Is that breaking the layoff?
well, if you're calling somebody in for 2 days and they're actually working 2 full days, you need to pay them, right? Slavery done whole heap of years ago. You need to pay them and if you pay them, it doesn't necessarily mean the layoff has to restart. You can have an arrangement where they will do a 1 day or 2 day here. As long as they're not brought back on a regular schedule, then the layoff period isn't interrupted. Can you call and ask for a file? Yes. I don't think that people are so unreasonable as to say, well, how much you going to pay me to tell you where the file is. I don't really think people are as wicked as that. But generally, I do encourage people to keep those kinds of, to be sensitive, and to exercise some discretion when you're asking somebody who would be in a very tough situation financially to do something without them being paid. And equally, I think employees should realize that, it's not the employer's fault that COVID is here or that the business has had to close down. In many cases, it's the government who has actually mandated that this business should shut down. So, we all have to be a little more understanding and work together to get through it. What I would recommend, however, especially in the hotel sector, we do have a lot of different regulations which have come out in anticipation of people being able to return, right? So sanitization regulations in the hotel sector, and essentially it's a whole new way of welcoming guests, which they have had to go and learn on the North Coast and the South Coast as well. Now, part of the challenge is if I need to bring in my staff for 4 days or 5 days to train them so I can get them back to work, should I be paying them for the time that I'm training them so I can bring them back? The truth is that there's nothing in the law that says anything about it, but I would like to think that if you're bringing somebody in, that you should be paying them something. It's not nice to come, and especially because you have to pay for traveling as well. It's not nice to have to reach into a pocket that's already empty to try and even do training. So I recommend try and pay some for that.
And one of the things that we've been saying throughout this program with the employer-employee relationship is communication, consistent communication, and compassion. So there is give and take on both sides. So before I get into my other questions, I want to just acknowledge 2 questions here. This conversation is very engaging. So Ingrid actually asked 2 times just to make sure that I saw the question. Can you comment on what is medical redundancy?
All right, gotcha. Good question, Ingrid. Medical redundancy is where you've either had a workplace injury or you've contracted one of a set list of medical conditions which are deemed to be workplace related conditions. So, for instance, I don't really know the scientific names, at least which I can't pronounce, but I recognize one of them as asbestos in cancer, something to do with asbestos. So if you contract that disease, it's going to be presumed that you contracted it as a result of the workplace, and so that you'd be entitled to medical redundancy. So what is not medical redundancy? Stress is not medical redundancy. Your hypertension, your sugar, those things which might affect your ability to do your job, but they're not on the list of occupational diseases, and so you don't get to claim them as medical redundancy. But if, for instance, you've had an accident at the workplace and you're now incapacitated or handicapped or disabled in a way that you can no longer perform the service for which you were hired, then you would be entitled to a medical redundancy. It's calculated in the same way as the other redundancies.
And that's something you would have to claim?
Yes, you could claim it. Very often these things have become obvious, so it's a discussion which both parties would have in consultation with the other. And very often, an employee will request medical redundancy even when it's not strictly speaking, a medical redundancy situation. For instance, I have an example of somebody who was in a motor vehicle accident on the way to work. Strictly speaking, that's not a workplace accident. But the employer in that case decided that they were going to treat it like a medical redundancy, and there was an agreement between the parties, and it doesn't really necessarily have to fall squarely in the law. If the 2 parties can agree on it, then they sort it out.
Okay. Kenny Fairmont. So thanks for that question, Ingrid. Kenny Fairmont, before we get to your question, I knew this would come. I see the PSOJ team, Financial Access team asking, what if I catch COVID at work? Is that list? I doubt that very much.
Yes, COVID, funny enough, is not on that list from 1970, how long. But truth is, that's an excellent suggestion that we should be making. Part of the challenge would be, of course, is proving where you catch the COVID, right?
COVID.
Because, I mean, yes, some workplace clusters are there, but even a workplace cluster, somebody started and brought it in from their
Somewhere.
home or somewhere else. So yeah, it's hard to really pinpoint a location, but not a bad idea. Not a bad idea.
Okay, so Kenny Fairmont asked, what advice would Mr. Goff offer to small biz owners without a HR manager during this time when outplacement is on the rise? What are some of the usual mistakes they should look out for to ensure they are not made?
I'm not sure I understand. When you say when outplacement is on the rise, I'm not sure I understand exactly what you mean.
Kenny, can you clarify that question? Do you mean outsourcing when outsourcing of HR is on the rise? But if we look at the second part of the question, what are some of the usual mistakes that are being made by small business owners during this COVID time as they're grappling with
All
layoff,
right,
redundancy,
cool,
etc.?
cool, cool. So, one of the major mistakes is not communicating and not consulting. All right. So, let's take an example of a business, a small business that needs to save some money, and they have, let's say, 50 workers who are all or more or less performing a similar function. I need to let go half of them, or maybe, yeah, let's say half of them.
Mm-hmm.
If it doesn't matter to you who stays and who goes, it might be that if you actually had a conversation with them, you'd hear that you have 15 people who are going to volunteer for redundancy because they already have some other plans which they want to take up. And if they were to resign, they wouldn't get the redundancy payment. So they've just been waiting for you to say the "rrr," and they're like, right? And if you were to have those people made redundant, that could easily save the jobs of 15 other people who are not in a position a financial position to deal with a blow like that.
Mm-hmm.
Similarly, you have some people who are, they just got in or they've been in a job for a few years now, and they've just applied for the NHT, and they've just sent a child to college,
Mm-hmm.
and they've taken out all these loans, and then a month after that, they're made redundant. And if you just let the employees know that the business is going through a rough time and that we might have to make some redundancies coming up soon, if you just send that signal out there, it allows your staff to have some control
Decisions.
and to plan, because even though they're entitled to notice pay based on their years of service, in addition to the redundancy pay, is simply not enough. The person who's now taken out a mortgage, it's not good enough that they're going to get 6 weeks notice of the termination. That can't pay a mortgage.
Yeah.
So communicating with your staff, I know sometimes it's embarrassing and you don't want people to know that you're struggling financially. I mean, I've had employers literally on the phone crying because they haven't taken any salary or any drawings out of the business in months, and they still aren't able to make payroll at the end of the week, looking to sell the vehicle. And sometimes if you just let people know in advance the challenges you're facing, you can find a solution to it together, and at least you can plan so you don't put yourself in a worse financial position. That's the number one mistake that small businesses make. The second mistake that small businesses make, and I'm not going to go into the full list of them, is that there are a lot of people who out there, professionals, who can give you good advice. You don't need to have an HR department, but as and when you need advice, there are a lot of people out there who are willing to assist you, and they won't even charge you an arm and a leg.
Yeah. And utilize these services. Don't try to figure out everything on your own. Thank you for that, Gavin, because that whole matter of communication, sometimes we are hiding things when
Mhm.
if we were transparent, we're able to plan differently for ourselves, but we also empower people to
Yes.
plan their own lives differently.
Mhm.
Um, now, Gavin, you have written about various options that employers can consider during this COVID time.
Mhm.
Um, Flexi time, reduction in the number of hours, shared working hours. Can you just talk to us about some of the different options that employers may seek to implement even as they're seeing just changes in their business? Can you talk us through that?
Sure. The most common solution that small businesses and large have been employing is they have been, instead of having a 40-hour work week, they have been paying people by the hour based on a reduced number of hours. So very often it means that your hourly rate will not change. Sometimes it does. But if you can't get somebody in, if you don't have enough work for somebody for 40 hours for the week, if you even have 25, if you even
Mhm.
have 20, it's better than zero. And so that kind of arrangement where somebody is now earning half of their salary, but they're also working half of the time, can be a good middle ground solution for both the employer and the employee. One of the things you have to be careful in that, though, is that if your salary has not changed, then all of your benefits, if you are to leave, are going to be calculated based on your new salary. I want to say that again. If your
Please.
salary has changed, whether it goes up or down, your last salary is what the law recognizes for the purposes of redundancy calculation and for payment of unused vacation, for payment of notice, and so on and so forth. So we have to be very clear that we understand the risks involved with salary cuts and with compressed work schedules. Anything that results in you taking home less pay could have a serious implication unless you come to an agreement with your employer about what those consequences should be in advance.
So suppose you have an agreement, so the employer has an agreement with the employee that says for July to September, you will work 20 hours per week at this particular rate. And it is clear that it's July to September. Come October, the employer realizes that they are unable to even continue that relationship and they are offering to make the person redundant. Given that specific agreement for July to September, is redundancy calculated on the June up to the June salary, or is it that July to September changed, reduced salary?
That's an excellent question. And honestly, we don't really know. Because what the law says is that law uses the phrase normal wages, but it doesn't really tell you what normal means in the context of what we're speaking about. So when they're using the word normal, they mean things like excluding overtime, excluding any of these special allowances which you might be taking. But and it might even include, for instance, what we're talking about, but it's just not that clear. So it's something that you would have to look at in each case. I would like to think that if the employer says that this is your new salary and it doesn't say that it is temporary in any way, I'd like to think that, or rather, I think what would happen is that that would be the salary, not the June. But if you have an agreement for a finite period,
Mm-hmm.
it's not so easy to answer. But it might well be that you go back into June then.
Okay. So Gavin, you have actually mentioned a couple of things that the law is silent on, or it's not clear what happens in particular circumstances. But before, because I would really love to understand what are some of the key amendments that you think need to be made to our law, and some of the things that have actually, like, you've probably been pankering on and asking about, and COVID has highlighted them. But I don't want to ignore, I see some questions here. So Ingrid, I see that. Who are those people? And that was to your comment, Gavin, of the persons who can give you good advice. I see you, Ingrid.
I know the
Ingrid asked about how. So, Ingrid, in regard to your question about assistance in operation management, at this time, I think you can actually go to the JBDC website, the Jamaica Business Development Corporation website, and there is information there on persons, various consultants in a plethora of areas.
Yeah.
Smallbusinessportal.com will also be offering information on various consultants, persons who are able to give you business advice, but also on smallbusinessportal.com, and JBDC also offers this. You're able to see lists of trainers, because there are actually a lot of courses going on now, so you can visit those websites. A man actually asked, what advice can you give for the work of being dismissed? Can negotiations even happen in a time such as this?
Negotiations are happening all the time, but the reality is that in every negotiation there's unequal bargaining power. In many negotiations like this, there's unequal bargaining power. Fact is that there's an oversupply of labor in the market, in the labor market. There are more people who are in need of jobs than those who have jobs. So it's a difficult situation. I would say this, that in the negotiation, if you are able to do that negotiation, we need to be focusing on that value which experience brings, right? So there are a lot of people coming right out of university right now who would love just to get their big toe in the door. And if that means that somebody who's been there for 20 years needs to go home and give somebody else a chance, they're willing to work for little and nothing. So it's putting a lot of pressure on our more senior people. But if you can kind of focus on the value that you bring, that somebody who just come a road isn't able to bring, that may improve your hand, so to speak. But I think as well, there's a place for loyalty. There's a place for preserving security of tenure. There's a place for ensuring that you don't discriminate based on age, which of course in this COVID time is being highlighted, because the old people are being, I think, literally discriminated against.
Yeah.
But the discrimination is really starting from the virus, and we're all reacting to it and sending home the old folks, or rather the more mature folks. So we do have to be sensitive to these things, but it's a tough negotiation, I can tell you that for sure. But Rochelle, if you don't mind, I really want to talk about the question you asked me about some of these changes that we can make, because honestly, I would love to get more support and bring more awareness to some of these really simple changes that can have such a meaningful difference in the lives of everyday worker and business as well. One of them is sick leave. I've been talking about sick leave a long time, and the fact that even right now, when you are in quarantine, but you're not exhibiting any symptoms, so you're not in isolation, you're not entitled to use your sick leave. By law, you are only entitled to sick leave when you're actually sick. What that means is that people are now going to work, they might have a little sniffle, but they can't afford to stay home for 2 weeks without pay. So they come in and they bring in the COVID into the workplace, because the law does not allow them to access sick leave unless they actually are seeing symptoms. And in this time where so many asymptomatic people are passing on the virus, we need to update our sick leave law to make sure that asymptomatic people can get their sick leave. Anyway, so thank you for that. Back to redundancy.
But I know there are some other areas, Gavin, for amendment, because that point that you made on sick leave, a lot of people are not even aware, and even persons of influence that we should be advocating. Sandra actually says, thanks for this section. It appears there is not much loyalty for persons with companies for a long period. So thanks for that, Gavin, too. Brenda, I just want to address Brenda's question quickly. When an employee receives his or her redundancy letter, does that employee have to sign upon receipt, or does one have the option of signing later and or discussing with an employment lawyer for additional negotiation with the employer?
There's no harm in signing to confirm receipt of a document, as long as you're not signing to confirm agreement or prejudicing your position before you've had a chance to take advice. So if somebody asks you to sign to confirm receipt, no problem with that. And then you can go and consult with a lawyer. If you don't want to sign to confirm receipt, at the end of the day, what are you going to do? Fire you again? So if you don't feel comfortable signing, don't sign.
Yeah.
Yeah.
So Gavin, in terms of the changes that are necessary in our law, because our law is not a young law, our law is a big smaddy. Sick leave. Many people are not even aware, and persons are calling in to say, I'm in quarantine. What about my sick leave? What else? What are some of the other critical provisions that need to be changed?
Cool. Critical provisions that need to be changed. We need to get those layoff regulations in place, the ones which are over 40 years overdue. We need to get them in place. So we need to ensure that we have a time frame, a reasonable time frame within which employers can make arrangements to pay their redundancy payment without being exposed to a lot of lawsuits clogging up the court system. So if you're going to say, for instance, that you must pay the redundancy within 6 months or 8 months or 9 months, so unless there's an agreement otherwise, I think that would be a good thing. I also think, and the PSOJ has been advocating for this as well, that this 120-day period needs to be looked at very carefully in terms of whether to grant a longer period temporarily to deal with COVID. Because the fact of the matter is that there are some businesses who have been shut down by the government for longer than 120 days, and it really isn't fair to them either to say, listen, I haven't had a chance to bring somebody back. If I brought somebody back in, you would haul me to jail. So it's really not fair that you say that I have to shut down for 4 months. I'm taking, for example, nightclubs, the nightclubs I know have to shut down for more than 4 months, and you're saying that you're not going to give them a little more time and a little more protection from redundancy claims. I don't really think that's fair either. So we need to look at that and determine where is the right balance between protecting small businesses and protecting the worker, and ensuring that we are evolving even faster than the virus is infecting.
Well, thanks, Gavin. So, and I'm seeing the comments come in. This has really been a very stimulating discussion. And you have pretty much touched on so many areas of employment. Kenny says our law is a big smaddy. Yes, Kenny. So Gavin, from where you sit, I don't think anything in our recent history as an independent country has highlighted deficiencies in our employment law, but also has highlighted for a lot of small businesses issues with their own management of human resources, as COVID has. So I can't let you leave with tonight, because you always have some little nuggets that you leave us with. What would you leave our small businesses with, coming out of just the various things that you are seeing? So I'm sure you get some cases that you're like, what? Please, what would you like to leave our small businesses with tonight?
I want to leave the small businesses with a message of hope, right? Um, we don't have much else in this time. The Bible says that, who by worrying can add even one more hour to their life. And the fact is that there are a lot of people who are worrying out there right now, and I understand fully why. But there is hope. There is light at the end of the tunnel. I think that Jamaica will bounce back and that we are already seeing very small pockets that recovery taking place. And I think that if we are creative and if we direct and focus our energies on finding those creative solutions, if we think about our fellow man and not just ourselves, if we try and dig deep into the resources of goodwill and every other altruistic feeling that we have, I really believe that we can find workable solutions to even the most difficult problems like COVID and all of the employment law issues which have resulted coming out of it. And I think that if you speak with the right people, people who have experience in dealing with these things, and if you speak amongst yourselves as members of the various groups, whether it's PSOJ or other communities, you will find that there's more information and assistance out there than you might otherwise realize. You are not alone. And you really need to try and reach out to the right people, get that information where it's available, and work together to rebuild. That's the message I want to leave with people.
Thank you so much, Gavin Goffe. And for those of you who are just joining us and are wondering how you're going to watch this episode again, somebody asked the question earlier. All our episodes and this very episode will be available right as soon as we're finished, as soon as we're done. It will be on the Facebook page. So please watch, comment, and share. Gavin Goffe is an attorney at law with Miles, Fletcher and Gordon. And Gavin talked to us today about managing redundancy. But he never just talked about managing redundancy. He really took us on a journey through employment law. Gavin, thank you very much for your contribution to our viewers. We really, really appreciate it. And we're looking forward to call upon you again.
All right. And thank you so much for having me, Rochelle. It's always a pleasure.
Thank you, Gavin. So for our viewers, we encourage you, watch, like, share. Please tell a friend. Don't just keep this information to yourself. Share this information. As you can see, it's episode 30, which means we have had 29 other episodes. They're all available on our Facebook page. They're available on YouTube. Please go back and watch. Send in your questions. We want to hear your questions. We want to hear your comments. You're also saying, where can I find the SME memos? Where, if I want to just go to one place and find everything, smallbusinessportal.com. Again, we are here every Thursday at 7:30 p.m. All of the information on the show is compiled into a document or SME memo. It goes out every week with accompanying information as well as references. So you can click on links and also get further information. And just again, Gavin mentioned, so for those of you who wanted information on the redundancy claim form, it is available on Miles, Fletcher and Gordon on their resource center. So you can visit their resource center. We are encouraging you to visit smallbusinessportal.com. It provides a wealth of information and business tip on just about every topic touching and concerning small businesses. If you're seeing a topic, if there's a topic you're looking for and you're not seeing, we want to get your feedback. We want to get your feedback on how you're able to navigate the website. We're looking forward to engaging you to make sure that it provides all the information you want. So please subscribe to our YouTube page, like, comment, and share. Visit smallbusinessportal.com, and every week, block the time, 7:30, to join us for another episode of COVIDCASTJA. By the way, next week, November 5th, cannot be missed, because we are going to be talking about living with COVID. We're going to be setting the baseline for living with COVID. What does that look like? What are these terms we're talking about? Comorbidity, asymptomatic. Somewhere I use the word, I want to know what it means. What does it mean? What are the current workplace protocols. What are employers supposed to be looking for? What are employees supposed to be looking for? What are some of the discussions going on with reopening of schools? Join us. We're going to be discussing all of these issues on COVIDCASTJA next week, Thursday. Roger, thank you so much. Max, thank you. Owen, thank you for your comments. And we look forward to another episode of COVIDCASTJA. Signing out. Wow, good. So you have a great idea to start a business, but you don't know where to start. We completely understand. You have lots of questions and almost no answers. Smallbusinessportal.com is here to help. At smallbusinessportal.com, you gain access to information on loans, grants, and investment opportunities from verified financial institutions. Guess what you also get? Useful business tips, access to training. All these services combine to make your business idea into a reality. Start your journey today at smallbusinessportal.com.